All right, let's go ahead and start. Let's put phones away. Anybody have any questions about syllabus stuff, papers? We're working on paper number 2. We'll get those back to you when we can. Raise your hand if you've started thinking at all about paper number 3. Okay, a few of you. So paper number 3 is described on the syllabus. It's due in 2 parts, like paper number 2, but both parts are longer than they were before, right? It's eventually going to be a 10-page paper. The initial part is to produce a partial draft, approximately 4 pages in length, and that initial part is due like a week following spring break. So if we come back on Monday after spring break, it's the following Monday, that initial 4-page part. And the prompt, which is long and detailed and on the syllabus, right, is to focus on some aspect of significant constitutional change during your lifetimes, right? So approximately the past 20 years for most of you. So during your own lifetime, right, identify some way in which the Constitution has changed. And then you're going to tell us how it's changed and why it's changed and whether it's been changing for the better or for the worse. So it's similar in some ways to the Warren Court paper, but focused on a more recent period of constitutional development. And you should not try to talk about everything that's happened in the past 20 years, right? You should try to identify some key things that have happened and link them together into some coherent theme, right? So I've been using this assignment for a while. The nice thing about it is that the 20-year period shifts a little bit each year, right? So there's different stuff that students have tended to pinpoint over the years. I have gotten very good papers that are focused pretty specifically on kind of like one area of the law, like marriage equality is something that has changed a lot in the past couple decades. And I have also gotten very good papers that tie together a couple different things under some coherent theme. So in this area of the law, and this area of the law, and this area of the law, one thing that's happened over the past 20 years is that the court has done X, right? Some coherent theme that links those different things together. So either version of that, a couple people have asked me about this, either version of that is fine. It can be really focused on one area of the law in which there has been some substantial amount of change, or it can link together some different areas of law in which there's been change under some common theme. Okay? So if you haven't started thinking about it yet, the first step, for sure, I would say, is to flip through the remainder of the course schedule on the syllabus. I mean, really, like almost all of the topics that you might choose to write about are things that we have already talked about. We just talked about them in the context of the 1950s and 60s. We haven't talked about, for most of them, we haven't talked about what's happened recently yet. So any topic that we've covered so far that's been particularly interesting to you, start with that one, look on the syllabus, jump ahead, find the part where we're covering recent developments under that topic, read some of those materials, and use that as a starting point. Right, I encourage everyone, this paper, since it's longer, I'm more on the Warren Court paper, I really encouraged everyone to stick pretty much to the assigned course readings. This one, I'm more flexible on that. If you want to bring in some additional stuff that is not on our syllabus, but that is relevant to your thesis, that is fine. But ideally, that additional material would be linked together with some discussion of material that is on here, right? So pick a topic that is connected to our syllabus and make sure to read some stuff that we are all reading and get that in the paper. But then if you want to supplement that by identifying some additional cases, additional recent Supreme Court decisions that we're not covering in the syllabus but that are relevant, that's fine too. But start with something that's on here. Questions? Okay. So our main topic today is the Watergate scandal. Not at all timely or relevant. So we'll talk about this a little bit. I'm going to start by playing a little clip from the oral arguments, right? So when a case comes to the Supreme Court, the lawyers file written briefs which lay out all their arguments, but then they show up in court in Washington, D.C., and they make brief oral arguments. Typically it's 30 minutes for each side. You'll see at the beginning here, Chief Justice notes that they had agreed to extend, this case was so important, they had agreed to extend the time in this case. But typically the whole thing is only an hour. There's no video cameras or still photography allowed, but the audio is recorded. And this website has all the audio files for all the landmark cases. So I'm going to play a little bit just from the beginning here, and then we'll talk about that a little bit, and then I'm going to play one other clip from the middle. So Warren Burger's the Chief Justice, who was appointed by Richard Nixon, right? He's going to talk first. Mr. Jaworski is the special counsel who's investigating the Watergate scandal.
Here are arguments in number 73, 1766, United States of America against Nixon.
The audio quality is not great.
And the Constitution, Richard M. Nixon against the United States. Mr. Jaworski, there has been a request for additional time. To advance that additional time of 1.5 hour, I understand. That's correct. Correct. It'll be allowed to each side, and we will not interrupt the argument with any recess. We'll go right through it to the finish. You may proceed whenever you're ready, Mr. Jaworski.
Chief Justice, and may it please the Court. On March 1st last, a United States District Court grand jury sitting here returned an indictment against 7 defendants, charging various offenses, including among them a conspiracy to defraud the United States and also to obstruct justice. John Mitchell, one of the defendants, was a former Attorney General of the United States and also chairman of the committee to re-elect the president. Another, H.R. Haldeman, was the president's chief of staff. Another, John Ehrlichman, was assistant to the president for domestic affairs. The others were either on the president's staff or held responsible positions on the re-election committee. In the course of its deliberations, the grand jury voted unanimously, with 19 members concurring, that the course of events in the formation and continuation of the conspiracy was such that President Nixon, among a number of others, should be identified as an unindicted co-conspirator in the bill of particulars to be filed in connection with the pre-trial proceedings. Now, although this particular decision and determination on the part of the grand jury occurred in February, it was a well-kept secret for 2.5 months. The grand jury, of course, knew it. Members of the prosecution staff knew it. It was done so to avoid affecting the proceedings in the House Judiciary Committee. And it was so kept during these 2.5 months until it became necessary to reveal it as a result of the President's motion to quash the subpoena, as I will indicate subsequently in my argument.
All right. What's going on so far? What do you got from this?
They've introduced President Nixon as kind of a conspirator officially into the court. And I guess he's stating that he's about to kind of outline the discretions that were involved.
What else?
just generally stating what the defendants. That's just introducing the case.
Say that again?
I said introducing the case.
Introducing the case, and what did you get about the defendants?
I mean, saying basically saying who is involved in the case, what are the stakeholders.
Yeah. Yeah, the former Attorney General of the United States, who was also the chairman of President Nixon's re-election campaign, President Nixon's chief of staff, his chief advisor for domestic affairs, and several other White House staffers are on trial in criminal court in Washington, D.C. for obstruction of justice, among other things. The grand jury that brought forth the indictments also secretly named several unindicted co-conspirators, which means we're not currently indicting these people with criminal charges, but we have seen evidence that they were involved in the conspiracy that these other guys are being indicted for. So to back up just a little bit, so this is in 1974. This is, I think it's July 1974. There's a date there behind the transcript, but I can't see it. So Nixon was elected in 68, right? And then in 72, he's running for re-election, sitting president running for re-election. In June of 1972, 5 guys got caught breaking into the Democratic Party headquarters that was located in the Watergate Hotel in Washington, D.C. They got caught by a security guard. Turns out that they were employed by President Nixon's re-election committee, although nobody knew that at the time. It was just a local criminal report of like breaking and entering as far as anyone knew at the time. That was in June 72, and Nixon gets reelected in November in a pretty big landslide, right? And nobody knows there's any connection to President Nixon with this break-in at the time. But some young reporters at the Washington Post, Woodward and Bernstein, famously pursue the story doggedly. They get some assistance from government employees who are willing to leak, to break the law, to leak some information, to help lead Woodward and Bernstein in a productive direction. And they start to draw some connections. The Washington Post reporters start to draw some connections to the White House, between the break-in and the White House. In February of 1973, the Senate sets up a select committee to investigate the matter. Right, the Washington Post has uncovered enough evidence that something weird was going on. Senate sets up a special select committee to investigate it. In May of 1973, facing considerable public pressure, Attorney General Elliot Richardson agrees to appoint a special prosecutor, right? And so the idea here is that the Attorney General is the highest-ranking official in the Justice Department, right, the top prosecutor in the country, and he reports directly to the President of the United States. So if you are trying to investigate alleged criminal activity by the President of the United States or his close advisors, or by the Attorney General, for that matter, or the previous Attorney General, right, the ordinary chain of command in the Justice Department might be slightly problematic, right? Every federal prosecutor reports to the Attorney General, right? The Attorney General reports to the President. How are they going to conduct a credible investigation, right? So the idea, which had been done before, although this is the highest profile example of it in history at the time, the idea is we'll appoint a special prosecutor who's not part of the ordinary chain of command and doesn't have to get like his budget decisions approved by the Attorney General, doesn't have to run proposed indictments by the Attorney General, right? He's like independent and autonomous and presumably can't be fired because you don't like the direction that the investigation is going, although the rules for what actual protections there would be at the time were not very clear, right? So Attorney General Richardson in May agrees to appoint a special prosecutor, and he appoints Archibald Cox, who's one of the leading, he's a law professor at the University of Chicago, he's one of the leading legal scholars in the country, right? Sterling reputation, not a partisan guy at all, right? Not associated with either political party, just a scholar. that's in May 1973. In June, John Dean, who was Nixon's former White House counsel, he testifies before the Senate Select Committee that's investigating, and John Dean implicates the president. Right? He says in testimony under oath that, oh yeah, the president knew about what was going on, the break-in and all that, all these other things that are coming to light. The president knew about all that. He also mentions that there's a secret Oval Office audio recording system that nobody knew about, nobody outside the White House knew about. In February of the following year, 1974, the House of Representatives authorizes the Judiciary Committee to initiate impeachment proceedings against the president. All right. In April of 1974, Special Prosecutor Cox obtains a subpoena from the federal district judge John Sirica, who's overseeing the grand jury proceedings. It's called a subpoena ducis tecum, which is the Latin word for a subpoena that orders somebody to show up in court and to bring certain specified documents, right? And the subpoena, approved by the judge, orders President Nixon to turn over certain specified White House tapes, right? Any White House tapes in your possession that include recordings of any of the following conversations involving any of the following people on any of the following dates, you got to turn over those recordings. In May, Nixon's lawyer files a motion to quash the subpoena, right, which is a written argument to the court saying, cancel this subpoena, right? You should not order the president to turn over this evidence. The argument in support of the motion to quash is executive privilege, right, which is not mentioned in the constitutional text, although every president, I think this is right, every president, certainly a lot of presidents, I'm pretty sure everyone, a lot of presidents dating all the way back to George Washington have asserted the concept of executive privilege, right, which is, privilege is a lawyer's word, right, it's like attorney-client privilege, right, your attorney cannot be forced to testify against you or to turn over documents that you have shown to your attorney in the course of dealings about your own case, right, your attorney can't be forced to turn those over for the obvious reason that the attorney is supposed to be your advocate. We're trying to protect that relationship. Executive privilege is the claim that the executive branch of our government cannot be forced to turn over certain information in its possession that it says is essential to the private, confidential workings of the executive branch. Right? That's the argument. Judge Sirica rejects that argument and maintains the subpoena, tells the president he has to turn over these tapes, and President Nixon's lawyer appeals to the Supreme Court, which agrees to hear the case on an expedited schedule, and these are the arguments in July 1974. I'm going to play you another clip from these in a second, but just put yourself back in 1974. Think about what's going on from a constitutional perspective here, right? If you took Con Law 1, think about how this kind of connects to some other constitutional developments we've talked about. From the beginning, right, there are disputes about the proper scope of the president's power under our Constitution. Right? The president is supposed to be important, right? He's the commander-in-chief of the Army and Navy, among other things. He's the chief executive. He shall take care that the laws be faithfully executed. But Article 2 does not spell out in a lot of detail what the powers of the president are supposed to be. And from the beginning, there have been instances where a president asserts that he has the authority to do something unilaterally, on his own say-so, and members of Congress or judges, or both, say, no, the president can't do that on his own, right? Can the president seize control of the nation's steel mills during war because a threatened labor action is going to disrupt the production of steel, which is going to harm the war effort? No, the Supreme Court says he cannot do that by himself, right? Congress could authorize him to do that, and then he could do it, but he can't do that unilaterally, right? So from the beginning, that's just one example. From the beginning, there's lots of disputes. By 1974, there is some increasing recognition that presidential power has grown a lot under our constitutional system since the founding, and maybe is getting out of hand, right? The idea that, like, it's not like every president is hiring people off the books and paying them with cash to break into the opposing party's headquarters. That is like over the edge, right? That not every president was doing that, but lots of presidents before Nixon were pushing the envelope on what they thought presidents were allowed to do and could get away with, right? Both Nixon and his predecessor, LBJ, right, so a Republican and a Democrat, both of them had unilaterally escalated the war in Vietnam and had lied, either they themselves and or their advisors had lied to Congress about what was happening, right? Blatant untruths told to Congress about who we were bombing, where, and when, right? And the presidents, in their minds, they're the commander-in-chief. They're supposed to be making these military decisions. Congress is a bunch of, like, meddling, like, legislators who don't know what's going on, and they're trying to interfere, right? And you can see how this gets justified in the minds of the White House. But there is a dawning recognition that the Watergate scandal is a symptom of a presidency that has gotten out of hand. Right? So I want us to talk more about what the court's going to decide to do about the Watergate scandal. That's one big thing. But I want to tie it together with, like, other debates that were happening around the same time, because there were multiple other debates in the 1970s about the appropriate limits on presidential power under our Constitution. So start with this. So Nixon's lawyer. So this is the other lawyer, right, that we heard so far. Jaworski is the special counsel. Oh, so the initial special counsel was Archibald Cox, who, when he requested a subpoena for the tapes, Nixon ordered the Attorney General to fire him. The Attorney General resigned on the spot and said no. Nixon called in the Deputy Attorney General and ordered him to fire him. He resigned on the spot and said no. Nixon called in the third-ranking official at the Justice Department, who was U.S. Solicitor General Robert Bork, and he fired Archibald Cox, which was known, the headlines the next day were the Saturday Night Massacre, right? So, like, the top two officials in the Justice Department just resigned, and then the third guy fired the special prosecutor on the president's orders because the president is unhappy about the subpoena that the special prosecutor is requesting. So there's public outcry, and the Justice Department sort of backtracks and appoints a new special counsel, right? They're like, we're not going back on the firing of Mr. Cox, but they eventually appoint Leon Jaworski to continue the investigation. So that's why Archibald Cox is not here. So Nixon's lawyer is Jeffrey St. Clair, and he makes three main arguments, right, to the Supreme Court. Remember, he is arguing to the Supreme Court that the federal judge that is overseeing the grand jury investigation should quash the subpoena ordering the president to turn over a bunch of White House recordings of conversations that may well have evidence of criminal activity. Right? Nixon's lawyer's arguments are, first, the president is immune from judicial process altogether while he is in office. No court can tell the president what to do while he is in office. He cannot be indicted, he cannot be tried, he cannot be forced to testify, he cannot be subject to a subpoena. There is one and only one constitutional means to punish the president for misconduct, and that is impeachment. And President Nixon, at the moment, has not been impeached. He's currently in office. The courts have no authority over him at all. That's the first argument. It's pretty sweeping. If that one doesn't work, the second argument is that, okay, all right, the president is subject to judicial process to some degree while he is in office, but there's a concept of executive privilege that is available to the president at his sole discretion to say, in any given instance, oh, that's material that I cannot turn over to the court, right? Anything that the president says has to be kept in secret on his own unilateral say-so, can be withheld from ongoing court proceedings. So that is less sweeping, because it acknowledges that some kind of legal proceedings can move forward against the president. But it is still pretty sweeping, because it says the president unilaterally can decline to turn over any evidence that he says has to remain secret because of its internal executive branch deliberations or national security or whatever else he wants to assert. And one of the problems with both of these arguments is that if you really believe that the president cannot be told what to do by judges, right? So the first argument is the president can't be subject to judicial process at all. Second argument is he can, but a judge can't force him to turn over any information that he says should remain secret. If you really believe that the president can't be told what to do by judges, then you probably shouldn't show up in court, right? Because, what are you doing in court? What are they trying to decide? Is there a case here that you could conceivably lose? In which case, I think the judge is going to tell you to do something, right? Why are you in court if you don't think that the court can assert any authority over the president? That is a little bit of a conundrum, right? Let me play another clip from the arguments here. Okay.
Whatever has been published to the public, we are quite prepared to verify the accuracy of. Now, in the course of those transcripts, there are first portions left out.
At any time tendered or proffered
But it's essentially a mechanical problem.
But in the case that they ask for a this subpoena to subpoena, which is the only thing before them, has any effort been made to say what, if any, part of that can be used?
Other than the 20 that are already published, no effort has been made as yet, sir.
Why not?
Because if you're honestly, we haven't felt that it's been necessary to do so, because we firmly feel that the president has every right to refuse to
You don't
produce them.
think that a subpoena to taken is sufficient reason for you to try?
But we moved to
You
quash
just
it.
ignored it, didn't you?
No, sir, we didn't. We moved to quash it.
And the difference between ignoring and filing a motion to quash is what? I want to hear that. What?
Well, if Your Honor, please, we are submitting the matter.
You're submitting the matter to this court.
To this court under...
Thurgood Marshall, the great trial lawyer, just forced Nixon's lawyer to admit that they are submitting the question to this court whether the subpoena should be quashed or not. Right? He said, you ignored the subpoena, right? He's like, oh, we didn't ignore it. We filed a motion to quash it. That sounds better. Right? And Justice Marshall's like, what's the difference between ignoring it and filing a motion to quash it? And one of the other justices was trying to interrupt. And Marshall's like, no, I want his answer. And he's like, what's the difference between those two things? And the lawyer's like, and Marshall's like, that you're submitting it to this court to decide, right? And he's like, yeah, in a sense, I guess, right?
A special appearance on behalf of the president.
You're still leaving it up to this court to decide it.
Well, yes, in the sense.
Well, in what sense?
In the sense that this court has an obligation to determine the law. All right? The president also has an obligation to carry out his constitutional
For
function.
us to decide whether or not executive privilege is available in this case.
Well, probably the question is even more limited than that. Is the executive privilege, which my brother concedes, absolute or is it only conditional?
I said in this case. Can you make it any narrower than that?
No, sir.
Well, do you agree that that's what's before this court and you're submitting it to this court for decision?
Which this is being submitted to this court for its guidance and judgment with respect to the law. The President, on the other hand, has his obligations under the
Are you
Constitution.
submitting it to this court for this court's decision?
As to what the law is, yes.
If
Of
that
course.
were not so, you would not be here.
I would not be here.
Why are you here if you're not saying that this court gets to decide whether this subpoena is legitimate or not? Right? His first two arguments are both that the president just gets to decide. But if you really believe that, don't show up in court. Just say, I reject the authority of the Supreme Court. I'm not showing up there because I'm the president and I'm in charge of everything. Right? If you are coming to court, you appear to be submitting to the court's authority to decide the question. So they have a third argument, right? First argument is the president's not subject to judicial process at all while he's in office. The second argument is he is subject to judicial process, but he can unilaterally assert executive privilege solely on his own say-so and refuse to turn over any evidence that he says shouldn't be turned over. The court is not going to go for either. The third argument is, okay, the president is subject to judicial process while he's in office. He can assert executive privilege in any given instance if there is material that he believes it would harm the U.S. interests and national security or whatever else to make it public. He can assert those interests. But if it's a question of what evidence is being turned over in an ongoing criminal case, it is up to the judge to decide. So the president can make an argument for executive privilege, but the judges get to rule on that, just like on attorney-client privilege, right? If you were saying, oh, no, I shouldn't have to turn that over because it violates attorney-client privilege, a judge has to decide whether that is right or not just because you said so, right? The judges have to decide. That's their third argument, and their third argument is, in this particular case, in the facts of this case, we have good arguments and good reasons for not turning over these tapes. And the judges should rule in our favor on that. And they lose on that one, too. The court, in a sense, agrees with that one. They agree that there is a concept called executive privilege that the president is allowed to assert, but that judges get to decide in any given case whether it applies or not. They agree with that, and they say in this case it does not apply unanimously. Right, including Chief Justice Berger, who President Nixon himself had just appointed, right, a couple years earlier, unanimously. The court rules against him. Nixon turns over the tapes and then resigns from office. And in the opinion written by Chief Justice Berger, he says, in the performance of assigned constitutional duties, each branch of the government must initially interpret the Constitution, and the interpretation of its powers by any branch is due great respect from the others. So the president, in performing his duties, certainly has to decide what he thinks the Constitution allows and requires, right? And so he can assert executive privilege in performing his duties. But in performing our duties, as a Supreme Court of the United States, we have to do the same thing. And we unequivocally reaffirm Marbury versus Madison's holding that it is emphatically the province and duty of the judiciary to say what the law is. Right? So there is executive privilege. We recognize the need for it in some circumstances. But we get to decide, right, in an ongoing criminal investigation where the president has in his possession evidence of criminal activity, apparently, right? A judge can issue a subpoena ordering him to turn over that evidence, right? It's noteworthy that in this case, both the prosecutor and the defendants wanted the evidence turned over, because, by this point, the attorney general and the former chief of staff and all those guys who are on trial, they're not just worried about helping out the president anymore, right? They are now on criminal trial, right? Facing lengthy prison sentences. And they were arguing, their lawyers were arguing, that there were things in the tapes that were going to help their clients' cases, right? And so both sides in the case were supporting the subpoena. The president, who was not a party at the time to the criminal prosecution, was saying he didn't want to turn it over. The judges are like, nope, unanimously, you got to turn that stuff over. That evidence is essential. Executive privilege is important, but in a particular case, it will sometimes be outweighed by the needs, the legitimate needs of law enforcement pursuing an ongoing criminal investigation. Questions about that case?
Who was also involved when they edited the tapes and took off the 18.5 minutes?
Yeah, so nobody knows. So Nixon, after the court's ruling, Nixon did publicly turn over the tapes, but there were portions that were erased, right? This is old-fashioned audio technology, right? These are tape. I don't know if you guys ever even seen it, like a tape. It's like recorded on like this long, thin ribbon of film. It's where the audio is recorded, and if you just record over it, right? If you cue it up to a certain spot and push record and don't say anything for 10 minutes, right? Then you have 10 minutes of blank silence on the tape. And there were several blank passages on the tapes when they did turn them over. And presumably somebody did that on the president's orders, but I don't think it, as far as I know, nobody ever demonstrably proved that. He then quickly resigned afterwards, so then the impeachment inquiry no longer goes forward because he's not in office anymore. And then Vice President Gerald Ford took the oath of office, became the president, and pardoned Nixon. So no criminal proceedings went forward against Richard Nixon either. So there's no full and final record of what. Obviously, lots of historians have gone back and looked at stuff and made conclusions, but there's no full and final legal record of what Nixon did or didn't do.
Why did Ford pardon Nixon?
Like the least charitable interpretation is as a deal in exchange for being appointed vice president on the clear expectation that he was then going to become president. Nixon's earlier vice president had resigned under scandal, and so Nixon had appointed Gerald Ford, who was a member of the House of Representatives, had appointed him vice president, and the investigation was already well underway at that point. So some people alleged that it was like a quid pro quo. I don't think there's any proof of that. Ford would say, I think it was time for the country to move forward, and I don't think we were going to get anywhere by having a crazy, criminal prosecution, right? The point is, if Nixon did something illegal, he's been removed, he's no longer president of the United States. That's the key thing. I don't think the country's going to get anywhere by criminally prosecuting him.
Plus, couldn't it, in the public's eye, it would continue to damage the institution of the presidency?
Sure.
Just weakens it?
Sure. So one of the issues, right, is if it could be the presidency, or think about any institution of government, right? If there is an institution of government that you think serves some important function, right, and if the current office holders in that institution abuse the powers of that institution regularly and in extreme fashion, such that folks are understandably upset, right? It would not be surprising if some changes are made to how that institution operates in the future. And some of those changes might be bad, right? I mean, it might be that the abuse of power leads people to get rid of an institution altogether, or to severely curtail its powers, to make it harder to do that bad thing, but also in a way that makes it harder to fulfill its functions, right? And so if you are a president, or if you are an advisor to a president, right, and you are participating in blatantly illegal activities, and then they come to light, obviously, hopefully you're going to get punished for that, legally But do you really care about the institution of the presidency? Do you care about presidential power? Then blatantly abusing presidential powers is probably not the best way to shepherd that institution, right? If it's good, maybe you keep it secret forever and everything's good. But if it comes to light, right, it is probably going to lead to some changes in how the presidency operates. And you're trying to expand the powers of the presidency because you think the president's the only one who knows what's going on, right? And I'm in charge of everything, and I should just get to do things on my say-so, and Congress is just interfering, right? But if you push the envelope too far on that, right, you're probably going to wind up, eventually, in our system of checks and balances, with Congress and the courts and the media and other potential watchdogs pushing back, right? And in fact, this is a major theme of constitutional development in the 1970s, right? Watergate is the biggest instance, but there are multiple other instances in which abuses of executive power came to light. Some of them came to light as a result of the Watergate inquiry, right? So if you've got committees in both houses of Congress, plus a special prosecutor in D.C. and a grand jury all investigating this stuff, they start to turn up all kinds of other stuff, right? Okay, so the FBI and the CIA and the U.S. Army are surveilling Americans engaged in peaceful democratic political activity without any judicial supervision. We didn't know that, right? Not just wiretapping, but also actually engaged in covert activities to disrupt the operations of peaceful political organizations, right? Sending in members, right, as plants, right, fake members who are actually FBI agents, and the fake members of the left-wing organizations are constantly encouraging the organizations to blow stuff up. Oh yeah, let's put a bomb under the police car at the rally. And it turns out later that was an FBI agent trying to encourage the people in the group to do illegal stuff so you could then arrest them, right? Over and over and over again, right? Sending fake letters to Coretta Scott King, pretending to be from Martin Luther King, and also sending real audio recordings to Coretta Scott King that really were of Martin Luther King. Just crazy stuff. And it's all coming to light, right? And Congress and the courts start to push back a little bit. There's in addition to the Watergate investigation, there's a famous committee called the Church Committee, led by Senator Frank Church, which investigates and holds hearings and then covers a lot of the sort of illegal sort of abuses of law enforcement power, right? FBI abuses of power in investigating and interfering with the activities of left-wing political organizations. Congress starts to push back. The courts push back, right, in cases like this. But Congress also starts to push back. In 1978, Congress passes a law called the Ethics in Government Act, which is an effort to respond to the Saturday Night Massacre. Okay, hopefully we're not going to have too many more instances of alleged criminal activity in the White House, but if we do, how are we going to investigate it in a way that doesn't allow the president to fire the investigator? So a section of that law creates a complicated, convoluted process for appointing independent counsels, right? So it's like the special prosecutor, but with a different title. If enough evidence is presented to the Attorney General to merit an investigation, and the Attorney General looks at the initial evidence and believes an investigation should go forward, then the Attorney General is supposed to convene a special panel of 3 federal judges, but he doesn't get to pick the judges. The Chief Justice of the United States picks the judges, right? And these 3 sitting federal judges, who remember can't be fired, right? They're appointed for life. The 3 sitting federal judges appointed by the Chief Justice, they pick a prosecutor, right? So they pick somebody maybe like Archibald Cox, right? Somebody with a sterling reputation, nonpartisan official, and that person is then authorized to follow the investigation wherever it leads, and neither the president nor the Attorney General can interfere with his budget or fire him. The only situations in which he can be fired are there's language about the Attorney General can fire him for like good cause, like if he is abusing his power, if the special prosecutor starts abusing his powers, the Attorney General can fire him, but the President for sure cannot order him fired, right? So that's a direct response to Watergate. That's enacted in 1978, and during the Reagan, first Bush, and Clinton years, there are multiple instances of special prosecutors, right? So there's like cabinet secretaries during the Reagan administration who are alleged to have done something illegal, right? And special prosecutors are appointed following these procedures. And it seems like it works more or less smoothly until the Clinton administration, when Ken Starr, who was an accomplished lawyer, but also a partisan Republican figure at the time, so he was a little bit of a strange choice by the 3 federal judges, but he's appointed as a special prosecutor to investigate Bill Clinton for shady real estate dealings in Arkansas in the 1980s. It's called the Whitewater Scandal, named after some bank in Arkansas. Starr's investigation goes on for years. He spends $50 million, and he winds up investigating Clinton's extramarital affairs in the Oval Office, which maybe that's President Clinton's fault, for nobody made him do that. But the scope of Starr's investigation grew dramatically from what he was initially appointed to investigate, that was controversial. It led to Clinton being impeached, although not convicted and removed from office. Congress then let the independent counsel law expire. They declined to renew it because Starr's investigation was so controversial. And so currently, if there are allegations of criminal activity by the president or any of his top advisors, it's back to the process that we had at the time of Watergate, right? Which is that the Attorney General, there's no statute that lays out these complicated procedures for appointing an independent counsel. It's just up to the Attorney General to appoint a special prosecutor if he or she wants to, and there is some somewhat vague protections in how the special prosecutors operate to prevent them from being directly fired, but not as strict as it was under the independent counsel law. And so our current special prosecutor, Robert Mueller, so it's a little more complicated, right? So Jeff Sessions is the Attorney General, but because there were clear allegations that he himself had met with Russians, he was an active member of Trump's campaign in 2016, and he himself had met with Russian officials, allegedly. He recused himself early on in 2017 from any Russia investigation, and so then it was up to the Deputy Attorney General to decide what to do, and the Deputy Attorney General appointed Special Counsel Robert Mueller. The President could at any time order Robert Mueller to be fired, which would potentially lead to a replay of the Saturday Night Massacre, right? Would the top ranking officials in the Justice Department agree to fire him or not? A few weeks ago, there were reports in the press that last year, last late spring, early summer, that President Trump ordered his White House counsel to call the Justice Department and tell them to fire Robert Mueller, and the White House counsel refused and threatened to resign, and Trump backed down.
When did that law expire?
I don't remember the year, but it was after Clinton's impeachment, and so Clinton was impeached in 96, 97, so it was sometime soon after that, I believe. I'm trying to remember if it was while Clinton was still president or if it was while George W. Bush was president, but I don't remember. I think it was maybe after George W. Bush came in. Yeah.
Are there any special counsel prosecutors during the Bush Jr. or Obama administration?
The Obama administration was remarkably scandal-free, right? There's political scientists who just study scandals and investigations because they become so frequent, and on one interpretation of it, since Reagan, right? So since 1981, divided government has been a pretty common feature, right? We've often had a president of one party and at least one of the houses controlled by the other party. And so one of the things, and we've had increasing polarization between the two parties, and so one of the things that appears to have resulted from that is there's more allegations and investigations of scandals. Because, like, if you think about, like, congressional Republicans, like, trying to investigate Benghazi, right? Did something actually happen there or not? Or is it just a made-up, like, investigation, right? And so sometimes scandal investigations are, like, drummed up by the opposition party. But even given that for 6 of his 8 years, Obama faced a Republican Congress, there were no special counsels appointed. There were some congressionally led investigations, like Benghazi. During George W. Bush, were there any special counsels? There was some weird stuff involving Vice President Cheney, like some alleged, like inappropriate, like, conversations with inappropriate influence of, like, energy industry lobbyists influencing some White House decision about energy policy. But I don't think that any of that ever got to a special counsel. If there were some, I would not be surprised if there were a couple during the Bush years, but I can't remember. Nothing, obviously, that rose to the level of what we have now, for sure. In 1971, to back up a little bit earlier, even so, some of this is happening even before Watergate. Congress passes a law called the Non-Detention Act, which was a response. So there was a Cold War era law, right, from the 50s, that authorized the Attorney General to order so-called executive detentions, right, to order that somebody be detained, right, jailed, on national security grounds, just on the Attorney General's say-so, right? So not convicted in court, not even on trial in court, right? But the Attorney General says on national security grounds this person has to be detained, and evidence came out that that power was being abused. And in 1971, Congress passes a law that repeals that provision and says, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress, right? So it is illegal for any agent of the federal government, including a CIA agent, including a member of the military, right? It is illegal for any part of the U.S. government to detain an American citizen except pursuant to an act of Congress, right? And the only acts of Congress on the books now are criminal laws, right, that would authorize the detention of American citizens, right? So if you're on trial for committing a crime, yes, you can be detained. Or if you've been convicted of a crime, yes, you can be detained. But otherwise, the executive branch by itself cannot order your detention. In 1978, so jumping back after Watergate again, Congress passes a law called the Foreign Intelligence Surveillance Act, right, which was in the news a lot during the George W. Bush administration after 9/11. It was enacted in 1978. It was an effort to put some limits on foreign intelligence surveillance, as the name suggests. Let me actually write something here. There's 3 different contexts in which government surveillance takes place. And the rules might be different for the 3 different contexts. First one is law enforcement, right? If the Syracuse police are investigating illegal narcotics trafficking in Syracuse, right? Sometimes surveillance is required, right? And the ordinary rules that would apply in that situation are the rules derived from the Fourth Amendment, right? No unreasonable searches and seizures. You need a warrant from a judge. To get a warrant, you have to produce evidence of probable cause, particularly describing what you're trying to search or seize, right? Listening to somebody's phone calls, the courts have held over time, is sort of like a search, right? It's an invasion of your privacy that is akin to a search. And so the Fourth Amendment applies, even though the word search literally is not quite right. But that would be the rule, right? The Fourth Amendment, and whatever precedents interpreting the Fourth Amendment the Supreme Court has, that's how you would decide what kinds of searches are allowed for ordinary law enforcement investigations. The government sometimes investigates and surveils Americans not because we are trying to collect evidence to prosecute them for a crime, but because we believe that they are engaged in activities that are harmful to national security, right? So Americans on American soil, but we think they are engaged in a conspiracy to assassinate somebody or something, right? They haven't committed a crime, so far as we know. We are not putting them on trial at the moment. That is not why we want to surveil them. We want to surveil them on national security grounds. Same logic might apply to non-Americans, right? So the CIA, for sure, is engaged in surveillance as part of covert activities in other countries. And to blur the boundaries a little bit between domestic and foreign intelligence, it might be that there are sometimes agents of a foreign power who are operating in the United States in a way that is a threat to national security. And so if they are an agent of a foreign power, then surveilling their activities even on American soil could plausibly be characterized as an act of foreign intelligence gathering rather than domestic, right? Is this distinction about the location of the surveillance, or is it about is the target an American or a non-American? It's a little bit fuzzy. But let's say that domestic intelligence means Americans operating on American soil. Foreign intelligence means either outside the United States or agents of a foreign power operating in the United States. And over a long history, like Congress and the courts had developed different rules governing these three different contexts for government surveillance. In 1968, Congress had passed a major crime control bill that said most of the bill was focused on ordinary law enforcement activities, but it also said that the executive branch could not eavesdrop on any Americans inside the United States without a warrant, right? The Nixon administration had been arguing that the Attorney General could authorize domestic intelligence surveillance without going to a judge, right? And that 68 law passed by Congress said, no, you can't do that anymore. The law expressly said, this does not apply to foreign intelligence, right? So we're not trying to limit the CIA's surveillance of enemies of the United States, right? Agents of the United States who are working against U.S. national security interests. Doesn't apply to that, right? They don't need a warrant. Abuses come to light of those powers too, and in 1978, Congress passes the new law that's an express effort to limit this. And the 1978 Foreign Intelligence Surveillance Act says that there will be a special federal court in Washington, D.C., called the Foreign Intelligence Surveillance Court. It's staffed by regular federal judges on like a rotating basis, right? So judges who are already sitting federal judges appointed for life get appointed temporarily to be a member of the Foreign Intelligence Surveillance Court, and they have top security clearances, right? So they can see all the classified evidence, and they get special training on what kinds of things we're looking for, what kind of evidence is relevant in these foreign intelligence surveillance warrant requests, and the court is set up in such a way that there is always a judge on hand, 24/7, right, available to quickly approve one of these requests, right? And so if the National Security Agency wants to surveil an agent of a foreign power, they go to this court, which typically very quickly approves the request. But the law says the procedures outlined here shall be the exclusive means by which electronic surveillance may be conducted. In other words, henceforward it would be a federal felony for intelligence agents to conduct electronic eavesdropping of foreign agents without going to the FISA court first. Right? So that is a clear effort by Congress to push back on what it perceives as overreaching by the executive branch. Right? The Nixon administration have been arguing that in both of these contexts, they can surveil anyone they want without approval by a judge. Right? And there were even some abuses in this context too, but in both of these contexts, their explicit argument was we don't even need to ask a judge. Right? Just on the Attorney General say so, we can surveil people, including Americans in this context. Right? Congress is pushing back against that. The courts also push back, right? So all these laws that get passed by Congress, they all have to get interpreted in individual cases by the courts. There was one case, I'm trying to remember if we talked about this, I think maybe really briefly. In our class on the Vietnam War and the Constitution, when we were talking mostly about free speech issues, right, like burning your draft card and that kind of stuff, wearing the jacket in the courtroom, did I briefly mention at the end some Fourth Amendment issues that also came up regarding the war? So there's one case from 1972 called U.S. versus U.S. District Court, in which it was a domestic intelligence case, and the Nixon administration was arguing, that Attorney General on his own say-so can authorize these warrants. It was a surveillance of an American who was like conspiring to like blow up a CIA office in Michigan, and the court ruled against the government unanimously. No, the Attorney General by himself is not allowed to authorize surveillance, right? There has got to be some checks and balances under our Constitution. We are not saying that all of the rules of the Fourth Amendment are going to apply exactly the same in these two contexts. The Fourth Amendment is basically a protection for criminal defendants, right? But if Americans are involved, the basic principle applies. You have to have a warrant. And that was unanimous. And so then, but that still was only domestic intelligence, right? That did not apply to foreign intelligence. And so then the 78 law is like extending those limitations on executive power to the foreign intelligence context. In addition to all of these laws, in 1973, Congress passes a law called the War Powers Act, right? Which is the most notable of all of these laws enacted during the 70s. A long quote from it on your handout. The War Powers Act, again, is a response to perceived abuses of presidential power. Both LBJ and Nixon had escalated the war in Vietnam without congressional authorization, and indeed had, in some cases, misled, and in some cases outright lied to Congress when doing so. And so Congress, once this comes to light, what? You've been bombing Cambodia, right? Even though you sent all these folks up to Capitol Hill to blatantly say you were not bombing Cambodia, right? This is no good, right? It's supposed to be Congress's power to declare war, right? We are going to push back. The preface or preamble to the War Powers Act makes a bunch of references to the Constitution, right? Congress's legitimate and co-equal role in controlling matters of war and peace under our Constitution. We are trying to reassert this role here. And then there's several key provisions. In sections 3 and 4 of the Act, it says, when possible, the President must consult with Congress before introducing troops into hostilities, and must provide detailed info to Congress about any ongoing hostilities. Right? So that's a direct response to the illegal bombing of Cambodia. Right? If at all possible, right, consult with Congress before initiating hostilities, and then provide detailed information to Congress about ongoing hostilities. Right? So the President is required to communicate truthfully with Congress about introducing U.S. armed forces into hostilities. In Section 5, it says that if consultation in advance is not possible, the president, as commander-in-chief, can indeed initiate hostilities on his own, right? Repelling a sudden attack, responding to an urgent, immediate national security threat that needs to be acted on right now, right? We have intelligence as to the location of Osama bin Laden, right? We're going to launch an attack tonight, right? You can't consult with Congress on that, right? First, right? When not possible, right? The president can unilaterally engage U.S. forces in hostilities, but he is required to notify Congress after the fact, and he is required to cease the engagement if Congress does not approve it within 90 days. Right? It says 60 days, but then he can request another month extension, so ultimately it's 90 days. Right? So president can initiate hostilities on his own, but he has to inform Congress, and Congress gets 3 months to approve it, and if Congress does not approve it, the president is required to cease those hostilities. So like a short military engagement, the president could still do on his own without Congress's support, but no protracted military action could be lawfully authorized without the support of Congress. Maurice?
Was there any enforcement or punishment put in place, if the president is just let's do that, because Congress has no military and the president has the greatest military ever. It's there's no way you could punish the president.
So, as with other disputes between branches in our system of checks and balances, right? It is sometimes a little bit difficult to figure out, who gets to decide in the end, what's going to actually happen. Congress, there's nothing in the act itself that would lead to any direct punishment of the president. Congress does have tools at its disposal by which it could respond to a president's failure to abide by the War Powers Act, but those tools are politically difficult to use, right? Principally, Congress could withhold funding for the effort, which Congress can clearly do. And could the president, if he was really determined, could he scare up some existing money in the Pentagon to keep it going for a while? He probably could, but not indefinitely. And so the principal potentially effective tool that Congress would have for enforcing the act would be to withdraw funding for continued military operations that it does not approve of, but that is really politically difficult to do, right? Because troops are in the field and Congress is saying we're pulling their funding, right? I mean, how are you going to do that?
Sorry, bro.
So that's the problem. Nixon vetoed this law. Congress passed it anyway, right? 2/3 majority in both houses. They passed it over his veto. Nixon, there's some excerpts from the veto message in your reading. Nixon argued it was unconstitutional. Some subsequent presidents have also argued that it was unconstitutional, right? Nixon's argument was that as commander-in-chief of the Army and Navy, I have independent constitutional authority, right, that does not rely on an act of Congress. Think about Justice Jackson in the Steele seizure case, right? Nixon is arguing that it doesn't matter which one of Jackson's categories you're in. It doesn't matter whether I have congressional support or not, because as commander-in-chief, I have independent constitutional authority to order the U.S. Army to initiate hostilities somewhere if I think it's in U.S. national security interests, right? Congress gets to decide to declare war or not, but the actual orders directed to the U.S. military about what they should do are only issued by me, and Congress can't tell me to cease an ongoing military engagement if I don't think that's in the U.S. national security interests. That claim has never been tested in court, right? A couple presidents have asserted it. The War Powers Act has operated to some extent, right, in the sense that presidents and their advisors have sometimes complained about it and have sometimes argued that it unconstitutionally limits the president's power as commander-in-chief. but they have also most of the time tended to try to comply with it, right? Because of, I guess, some worry that it would be politically controversial, right? If we got folks going on TV saying the president is engaged in an illegal war, he's not consulting with Congress at all, that's something that the White House has to deal with politically, right? So the presidents never want to acknowledge that Congress can tell them what to do, but most of the time, right, they have gone to Congress for support. When President George W. Bush, right, in the immediate wake of 9/11, he said we want to launch an attack on the Taliban regime in Afghanistan, which is harboring Al-Qaeda, who are the perpetrators of the attacks. There was very close to unanimous support in Congress for authorizing that. And then, what was it, like a year and a half later, the president and his advisors say we want to go to war in Iraq as well to unseat Saddam Hussein's regime, which had nothing to do with the 9/11 attacks. And there was less consensus on whether that was a good idea, but there still seemed like there was probably majority support in Congress for it. And the Bush administration went to Congress, and they said, we want your support. And Congress authorized the military action in Iraq. Hillary Clinton famously voted for it in the Senate, which proved controversial a few years later when the war was not going that great, and a lot of people had concluded it was a mistake. Barack Obama had been opposed to the war from the beginning. I mean, he was just like in the state legislature in Illinois, but he had like shown up at an anti-war rally and given a speech and had been opposed to it from the beginning, and that played a role in the 2008 Democratic primaries. Bush administration went to Congress, and they got Congress's support. However, meantime, lawyers in the Justice Department and the White House had also written all these secret memos saying, well, the president's allowed to do this whether or not Congress supports it, so I guess let's go to Congress because I think we're going to get their support. But if they don't support it, we can still do it if we want, right? And so that was secret at the time and only came to light later. But that is another indication of a president who and his advisors who, like Nixon, are arguing that the War Powers Act unduly tries to restrict the president's independent constitutional powers, right? So just like the dynamic here is, throughout the course of the 20th century, presidential power is growing. Most of the time, most presidents are not doing stuff that is blatantly illegal, hopefully, but they are pushing the envelope, right? They are trying to do things unilaterally, like seize control of the nation's steel mills and such, that previous presidents hadn't done. And over the course of the 20th century, those precedents like build on each other, and presidential power is getting bigger and bigger. Then some of the presidents do stuff that is blatantly illegal, and scandals come to light, and so there's a lot more attention on what presidents have been doing. And then Congress and the courts start focusing on, oh, well, not only that, but Nixon administration was also doing this. And remember what the LBJ administration was doing? They authorized this on their own. They didn't even come to Congress on that, or they misled Congress on that. And so there's a major effort by both Congress and the courts to respond by pushing back and imposing some limits on presidential power under our system. Are the limits enforceable? That is complicated. Do they succeed in, I think forcing is the wrong word, incentivizing presidents to seek more consultation than they had sometimes been seeking? I think they do succeed on that front, right? After the War Powers Act, on average, presidents are engaged in more consultation with Congress prior to initiating military hostilities than they were previous to the act. But do they succeed in completely preventing the presidents from doing this on their own? No. Under Obama, Obama authorizes a bombing in Libya, right? A bombing campaign in Libya, where it is unclear whether there would be majority support in Congress for the effort. And in the president's judgments, it's in U.S. national security interests. And if I am remembering the sequence of events right, they did not go to Congress prior to authorizing that bombing campaign. They did inform Congress of it, right? So the president launched it on his own, but they did inform Congress in writing of here's what we're doing and why. But there was legal language in the written information to Congress trying to create some wiggle room to suggest that this was not an initiation of hostilities that would invoke the rules of the War Powers Act, right? So what they were trying to say, in lawyers' words, was that even if Congress, we don't know how long this is going to take. Hopefully it's going to be quick. We think it's going to be quick. We think there's no danger of U.S. casualties. There's no troops on the ground. It's just a bombing campaign. But if it turned out to take longer than we thought, and Congress did not approve it within 90 days, we are not acknowledging that we would then be required to cease it. Right? We are saying this is not an initiation of hostilities. This is something different legally, and the War Powers Act doesn't apply. So there's been constant negotiations. One of the things that we'll see next, to continue the story forward, is that all of the presidents after Nixon, to some extent, but particularly George W. Bush, because he's president during the 9/11 attacks, right? Really start to push back again. Right? So the story in the 70s is Congress and the courts pushing back, trying to curtail presidential power to some degree. And then the story following 9/11 is really the president pushing back the other way really hard. And saying Congress and the courts have been trying to curtail us too much. I'm the commander-in-chief. We get to decide what's in U.S. national security interests, and we're going to do it on the president's say-so. So that's the preview of where this story will continue. That's all.